Blog Talk Radio.
You are now listening to True Murder, the most shocking killers in true crime history, and the authors that have written about them. Gacy, Bundy, Dahmer, The Night Stalker, BTK. Every week, another fascinating author talking about the most shocking and infamous killers in true crime history. True Murder, with your host, journalist and author, Dan Zupansky.
Good evening. A tragic suicide, a likely murder, wrongful imprisonment, and gripping courtroom scenes draw readers into this compelling story, giving them a frightening perspective on justice corrupted and who should be accountable when evidence is withheld. License to Lie, Exposing Corruption in the Department of Justice, is the true story of the strong-arm, illegal, and unethical tactics used by the headline-grabbing federal prosecutors in their narcissistic pursuit of power. Its scope reaches from the U.S. Department of Justice to the U.S. Senate, the FBI, and the White House. This true story is a scathing attack on corrupt prosecutors, the judges who turned a blind eye to these injustices, and the president who has promoted them to powerful political positions. The book that we are featuring this evening is License to Lie, Exposing Corruption in the Department of Justice, with my special guest, attorney and author, Sidney Powell. Now, I apologize to our audience. There has been a little mix-up on Blog Talk Radio in terms of the countdown for the program, and so when she called in, Sidney Powell, she experienced a problem, so I have just emailed her back in the last 3 minutes or so to please call back in. So it was a Blog Talk Radio technical error, so we should have her on in a couple minutes. Sidney Powell is a former prosecutor who became a defense attorney, and we'll ask her what that change was and when that change was, and we'll talk all about her background. And then her incredible book here, talking about exposing corruption in the Department of Justice. And this is an insider's look at something that we normally don't get to see and we don't get to hear about whatsoever. We hear stories of overzealous prosecutors for various reasons, and I, being in Canada, we have a different system which takes the political, climbing or political aspirations out of the equation in terms of judges and prosecutors. So we have a different system, and I believe, just from the experience, from the stories I have witnessed through true crime books and through this book, it reinforces that's a system that's open to a lot of problems. But we hold the judicial system up to a higher standard than any other standard, and certainly they're afforded that kind of respect. And as such, as citizens who are tax-paying citizens and citizens who believe in these systems of government, and this is an extension of government, especially federal prosecution, but really the judicial system is an arm of the government, and as such, we are entitled to understand the process and then demand that each party, the defense and the prosecution and the judge, abide by the rules that are clear-cut, possibly evolving, but still clear-cut. And this will be a book that will demonstrate that often that is not the case, and with dramatic and very, very dramatic results. So again, I apologize for Sidney Powell, but I'm sure she will get this email and be able to call back in, and we can interview her about this book, License to Lie. What we'll be talking about in this hour is things that no matter who you are and no matter where you were in the past, you will have heard names like Alaskan Senator, 40 years in the Senate, Stevens, and Senator Ted Stevens. And we will also hear about a company that was famous and a golden boy in the press for many years and then not so much, Enron, an American company. And we'll talk about that. And we'll talk about her personal experience in this so that, again, we're getting an incredible insider's viewpoint, vantage point. And so when we talk about problems, when we talk about things that arise in trials, when you're getting a actual account of something from this perspective, this is unique. Usually a true crime author is not in this kind of position. There are true crime authors that often are prosecutors, and there are some great books like Killer Clown and Helter Skelter, written from, of course, with the help of writers, but still the story coming from the incredible, unique vantage point, perspective of somebody in that position, a prosecutor prosecuting someone accused of some incredible crime, and usually multiple incredible crimes. So in this case, a woman, a strong woman, advocating for the innocent, and incredibly, this is unfortunately, a glorious example of injustice within the judicial system in America, and we're talking about federal prosecutions as well. And so everything from murder and suicide and career ruining and traumatization of families and the incredible cost of attorneys and the trial and the subsequent loss of work. So incredible toll when injustice rears its ugly head. Again, I'll apologize to the audience. I won't give this too much more time. Unfortunately, I've had a lot of criticism for not being able to have the guest and I coordinate on the time. So again, I guess I'll take the blame here, and we'll just wait a few more minutes, and hopefully I can entertain you with some more ramblings. I want to also say that I've been looking at a few interesting cases that have come out of Winnipeg, Manitoba, and I really have not been focusing on criminal murder cases here in Winnipeg. I mean, there are some incredible cases. This is the murder capital of Canada and the 9th biggest city in Canada, and one of the poorest with all the ingredients and factors there for the kind of place that's a little, quite a bit more prone to violence and again, murder. And for anyone that's listening from Winnipeg, of course, they will cringe, but that is the truth, that long-standing record as murder capital of Canada. And now, in comparison to an American city, we are still very, very low murder rate in comparison. So here we are with Sidney Powell, thank God. And I appreciate that you hung around to listen to this. So here we go with Sidney Powell. Good evening, Sidney.
Hi, Dan. How are you?
Oh, fine, thank you. Thank you very much. I was tormenting the audience with about 8 minutes of improvisational rambling, we'll say. So thank God you got on the line here. Yes. So I already introduced the book in terms of giving a synopsis of the book. Let's start with this, Sidney Powell, with give us, the audience, your background before we get into this incredible book and this undertaking that you have with this book. So give us your background. I understand you were a former prosecutor, so give us your legal background, please.
Okay. I actually wanted to be a lawyer from the time I was 5 years old. My mother tells me that I would go home from kindergarten and watch Perry Mason. And at the end of first grade, when everyone asked, what do you want to be when you grow up? And we had to stand up and announce that. I stood up and announced I wanted to be a lawyer. And all my life, people would say, oh, you don't want to be a lawyer. There are too many lawyers. And my standard answer was, there are not enough good ones. Mm-hmm. So I went to undergraduate school at the University of North Carolina, got my undergraduate degree Phi Beta Kappa, and did my undergraduate work in just 21 months and proceeded to law school. Interned my first summer after law school with the U.S. Attorney's Office in Raleigh, North Carolina, and after that with the U.S. Attorney in San Antonio, Texas, and that U.S. Attorney decided to hire me back. So I became the youngest assistant United States attorney in the country at the time. I graduated from law school and was an AUSA in San Antonio. I worked in the appellate section there for a year or two, then did criminal trial work for a year, civil trial work there for a year, and rotated back and wound up heading up the appellate section for the Western District of Texas, where I filed over 350 briefs in criminal appeals, became editor-in-chief of the Fifth Circuit Reporter, served on the Bar Association of the Fifth Federal Circuit, and numerous other organizations, became an elected fellow of the American Academy of Appellate Lawyers, for which I served as president, became president of the Fifth Circuit Bar somewhere in there, and then went into private practice after 10 years with the government. I've only actually represented criminal defendants in 4 cases after I left government practice, because I can't take a case unless I feel like I'm on the correct side. So that kind of limited my criminal defense work.
Right.
And
now you say that you left federal prosecution as a federal prosecutor after 10 years and went into. Why was that? Why did you leave?
There were several reasons. I thought it was important for my own personal growth. And when I looked around and saw people that had stayed for longer than 10 years, they seemed to get jaded and tired and cynical and just not have the edge that I felt like I wanted to maintain, and the freshness in an approach to the cases and the practice. So I didn't want to get stale.
Now, in terms of prosecutorial misconduct, and really that's what this book is about, had you experienced that as a prosecutor and working in an office? Had you experienced a lot of the things that are later that you really aptly demonstrate in the book with the stories that you have covered in this book?
No, I actually experienced very little of it. I mean, we're talking 20, 25 years ago that I was in the United States Attorney's Office, and I was in 3 different divisions under 8 or 9 different U.S. attorneys. None of the U.S. attorneys I knew would have put up with anything like what I talk about and found in the book. None of them would have. I mean, we would occasionally have an assistant U.S. attorney who would get overly aggressive in argument and say something they shouldn't have, or introduce a piece of evidence that was too prejudicial that shouldn't have been introduced. But in terms of anybody hiding evidence that exculpated or exonerated a defendant, I never knew of any instance of that. And I knew the folks in each of our offices very well. I mean, that wasn't what they were looking to do. We were taught and trained that the job of an assistant United States attorney is to seek justice. And if a criminal defendant went free and we had still done the right thing, that was the way it was supposed to be. The job was not to get convictions. It was to seek justice. And that was hammered into each of us. That's what I taught in the Attorney General's Advocacy Institute 3 weeks a year for 7 or 8 years. And that's what people taught me. That's what was expected of us. And that is why I was so mortified when I saw the conduct that I saw that is reflected and discussed in the pages of the book.
What do you attribute this change, though? It must have been it seemed a very, very dramatic change in terms of the prosecution's focus, in terms of, you say, just to win at all costs, rather than especially the federal court being the highest standard of, especially under scrutiny, you would think, potentially, so that it's a very, very high standard. What do you attribute this dramatic change in focus for prosecution?
I think there's been an unfortunate increase in the politicization of the Department of Justice. I think with the advent of instant media in all forms, there's been a lot more pressure on prosecutors, particularly in the high-profile cases, to obtain convictions. I think it's a number of things like that, and maybe even certain people have sought out the job because of the publicity that can go with it, or the public spotlight that can go with it, as opposed to doing the job because they want to do it with honor and integrity. I think it's a mixture of things.
Just so I get this straight. Go ahead, sorry. I
was going to say, definitely, I think in the last 15 years or so, the Department of Justice has just become increasingly politicized. When you're saying politicized, let me try to understand this. Does this come down to, and I know it's in terms of people looking to achieve higher positions politically and within their own occupation, but is there any consideration to the idea of who's conservative and who's liberal, and is there any of that involved in this politicalization? I think the Attorney General basically sets that tone. There are a number of people in Department of Justice who have been there forever, and in some ways that is a good thing, and in some ways, like people staying in a U.S. Attorney's office too long, that's not a good thing. I mean, I really don't think anybody should probably be in government service more than 10 years, and that there should be fresh blood flowing through there and new ideas and, sort of a hunger to get things right and actually seek justice instead of a jaded or worn perspective on the system. But, the president gets to pick the Attorney General, and it's been more and more characteristic for that office to be used sort of as an arm of the executive branch with overriding policy considerations, as opposed to an entity that seeks to enforce the law in a blind way. And that, I think, is unfortunate. Why would this particular Democratic government and president, why would they be inclined to do that? I don't know, but I think most people looking at this administration at this point, between the NSA issues and the president's use of executive orders to circumvent different rulings of the Supreme Court and courts in general, would say that this administration has certainly done more to put in jeopardy the freedom of the press than any other administration in history, and has also used Department of Justice to seek certain ends. I'm not saying that the prior administration didn't do some of that too. There was a big controversy with Alberto Gonzalez firing the U.S. attorneys from across the spectrum and other issues. Right. But in general, I would like to see the Department of Justice restored to an organization that purely seeks to enforce the law without regard to political perspectives. Now, in your book, in the foreword, they talk about prosecutorial misconduct. And so for those that don't know or haven't heard enough of the various things, I'll just describe them, and we can talk about them a little bit.
overcharging in terms of the number of charges, deliberately mishandling, mistreating, or destroying evidence, allowing witnesses they know or should know are not telling the truth, truthful to testify, pursuing defense witnesses or pressuring defense witnesses not to testify, and relying on fraudulent forensic experts. Also, during plea agreements, overstating the strength of the evidence in the case and making statements to the media that are designed to create public outcry, making improper or misleading statements to the jury, and failing to report prosecutorial misconduct when discovered. Is this... Talk about this a little bit. Tell us a little bit about this.
Those are all things that have been outlined by the Center for Prosecutorial Integrity, a new nonprofit organization that has been formed to try to encourage change in this area. They did a study and identified those different aspects of prosecutorial misconduct. And Judge Kaczynski, in writing the foreword for this book, pointed to that study and recited those things as instances of different kinds of misconduct. The book itself deals more with prosecutorial misconduct in the form of hiding evidence that would have exonerated the defendants, telling the court things that were directly the court and the jury things that were directly contradicted by the evidence they withheld, and definitely putting pressure on witnesses not to testify for the defense. There were scads of that in all the Enron-related prosecutions. And overcharging. I mean, basically, if a defendant was willing to plead guilty, they got an indictment on one count or were allowed to plead to one count. And if someone didn't plead guilty, then the counts were stacked against them. And if anyone voiced a view of the facts or evidence that was different from that of the Enron task force, they also threw in charges of false statements or perjury or obstruction of justice, things like that.
Wow.
Yeah.
Now, when you talk about withholding potentially exculpatory evidence, this is the Brady rule.
Right. Supreme Court in a case called Brady versus Maryland held that a defendant has a constitutional right to the evidence that the government has or can obtain that is supportive of his defense or would impeach the witnesses against him or would affect his sentencing. And there were scads of Brady evidence in this case. In fact, the prosecutors had actually yellow highlighted it for the judge before the trial, and still, after the judge ordered them to produce summaries of it, presumably accurate summaries, they still hid the key statements and evidence from the defendants while they served a year in prison for a crime that wasn't even a crime.
Now, before we get right into that and trying to understand this incredible trial, what's interesting, I think, is that most people know that if it's a bad guy, a really bad guy, then we've watched television and we understand that the prosecutor would be more eager to try to bend the rules to bust a guy or bust people that are monstrous and they avoid prosecution time after time. But in this, holding back potentially exculpatory material on people that are in business or in government, why would, again, that's why I asked the question about politicalization. It seems somewhat political or personal or something else when they're that zealous and vigorous in their prosecution of people that are not what people would think are typically the bad guy.
Right. There's been an also increasing trend toward what's called the over-criminalization of the law. Prosecutors stretching to make crimes out of things that are really civil issues.
Okay.
And what separates a civil issue from a criminal issue is really criminal intent. I mean, if you don't intend to commit a crime against someone, it's usually covered, and it's still wrong, and it's not that hard to tell if something's wrong. It's usually covered by civil law. And most of the Enron and Enron-related offenses could have been covered and should have been covered by civil law, and instead there was such public outrage and public outcry in the wake of the collapse of Enron. The Department of Justice immediately appointed the Enron Task Force, untethered them from the Department of Justice so they had no adult supervision, and set them about to, find the criminals. And they simply got way overzealous in their effort to do that. They made crimes out of things. They took pieces of different statutes that had never been put together to create a crime before and said, oh, this is a crime, and indicted it and indicted people who were doing business deals and thought they were well within the law in what they were doing. In fact, they were relying on their own corporate counsel in doing it, and wound up serving a year in prison for something, as it turns out, was not a crime, because even the Fifth Circuit would not give them bail pending appeal. The outrage was so strong.
Incredible.
Yeah. I mean, it's really in times of widespread public animosity that lawyers have to work the hardest to protect individual rights.
Now, where does this media contempt come from, though? Was any contribution from, again, the prosecution itself, or did the media just like to spin it a certain way, the big, bad, rich people and us against them?
Well, at the time, Enron was such a huge loss, a financial loss and emotional devastation for so many people, that public outrage was broad and deep. Houston itself was absolutely devastated. I mean, Enron had something to do with almost every charity in Houston, gave business to all kinds of businesses in Houston, supported I don't know how many banks with its multiple transactions, big banks, international banks. I mean, it was a titan at the time and well regarded at the time. So when it went down so suddenly and so badly, hundreds of thousands of people lost scads of money. Some people lost all their savings, all their retirement accounts. I mean, people had a right to be angry. But for prosecutors to put people in jail that didn't belong there and make up crimes and hide evidence to do it is as bad an offense as anything they sought to prosecute.
Now, you write about Senator Ted Stevens, and he died in a plane accident. But tell us about Senator Ted Stevens and why you included him in this book. What does his story demonstrate?
His story, juxtaposed against that, particularly of the Merrill Lynch defendants in the Enron litigation, provides a very interesting contrast. Senator Stevens' case was tried by Judge Emmett Sullivan in the District of Columbia, and Judge Sullivan was far more alert to the possibility of prosecutorial misconduct and willing to examine the allegations of that than was United States District Judge Ewing Werlein, who was sitting in Houston in the midst of the Enron outrage. So just the view of the way the two different trials were conducted is an interesting study and examples in themselves. And also the prosecutorial misconduct, as it turns out, when I overlaid the two cases, has a common denominator in the work of a man by the name of Matthew Friedrich, who went from being co-counsel on the Merrill Lynch Enron prosecution to he rose meteorically through the Department of Justice upon the backs of the wrongful convictions in the Enron cases to become acting Assistant Attorney General heading the entire criminal division of the Department of Justice when he had only 15 years experience as a lawyer. And he oversaw and was the puppet master pulling the strings of the trial prosecutors who unseated Senator Ted Stevens, the longest-serving Republican in the United States Senate, changed the balance of power in the Senate, and basically helped enable the enactment of Obamacare by unseating Senator Stevens. In that case, they also hid the evidence that showed Senator Stevens' involvement was not as the prosecution had represented, and definitely undercut the prosecution's main witnesses. But Judge Sullivan saw that and was willing to do something about it. He appointed a special prosecutor. He dismissed the charges against Senator Stevens before they came to judgment, and he appointed a special investigator to investigate the Department of Justice and the prosecutors themselves. That produced an extraordinary amount of evidence. Hank Schulke and Bill Shields in D.C. were the special prosecutors. They wound up producing a 500-page report, much of which is referred to in the book, that outlines the various conversations and some of the misdeeds by the prosecutors in that case. And again, nothing like that. We couldn't even get a motion for new trial heard in the case against the 4 Merrill Lynch executives. And that's attributable to the difference in the judges primarily.
You also include the story of Nicholas Marsh. Tell us who Nicholas Marsh is and what happened to him.
Nicholas Marsh was one of the young prosecutors in the Public Integrity section of the Department of Justice who had been working on what was called the Operation Polar Pin investigation of public corruption in Alaska for several years. I think it started about 2 years after the Enron Task Force began its work. And Nicholas Marsh worked under Bill Welch and Brenda Morris in the Public Integrity section at Justice, and was leading the Polar Pin investigation. He would have been the person to lead the prosecution of Senator Ted Stevens. And at the very last minute, after Matthew Friedrich and his deputy Rita Glavin were installed to head the Department of Justice Criminal Division, Matthew Friedrich rushed the Stevens case to indictment, and then I think the day before, day after it was indicted, took Nicholas Marsh off as lead counsel, put Brenda Morris on as lead counsel, basically disrupted the entire trial team, and gave Morris certain marching orders. Nicholas Marsh was upset, needless to say, about being taken off as lead counsel, but he was working behind the scenes. I think he was third chair in the trial itself. His roles were cut back considerably. He felt disregarded and disrespected, needless to say, from that endeavor, and it was frustrating for him to watch everything that was going on. Then when the whole case unraveled and it became apparent that evidence had been withheld, the investigation turned on the prosecutors themselves. Everything I read indicated that the stress of being the subject of an investigation was more than Nicholas Marsh could bear. He had felt like he wanted to devote his whole life to Department of Justice and to the law, and he thought this would be a black mark on his career forever. I talk about what he suffered and endured because whether he was right or wrong in whatever it is he did in terms of the Stevens prosecution, the ultimate toll was the loss of his life because this bright, capable, much loved by his family and friends young man wound up committing suicide before Schulke finished his investigation. And I call it the ultimate toll. And it shows the stress that every person who is the subject of a government investigation feels, I believe. I know the stress on my clients of almost 10 years of being the target of a government investigation was absolutely extraordinary. If it hasn't happened to you, you are extremely fortunate, and you cannot imagine what it does to your family and relationships all across the board to be told you're going to be indicted by the feds when otherwise the whole world thinks you're a law-abiding citizen and you thought you were too.
Now tell us about the defendant that you chose to defend, and you say that it's very rare that you've only had 4 defendants that you've chosen to represent. So tell us about this defendant, and because you have a personal relationship with this person one way or another. So tell us about your defendant and what happens to him before trial, after trial. Tell us a little bit about this story.
Okay. I represented Jim Brown, who was head of Merrill Lynch's Global Asset and Leasing Management Department. Most people don't know that Merrill Lynch actually had a significant dollar amount of hard assets, and Jim's group managed those. His role in the case was extremely limited. He actually went on vacation, for Christmas vacation. All of this happened like December 21 through 23 of 1999, I think it was. Mm-hmm. And it boiled down to a 5-minute telephone conversation that my client, Jim Brown, was not even on, between Andy Fastow at Merrill, at Enron and some other folks at Merrill Lynch. And the government claimed that Merrill was being given a guarantee by Enron that Enron would buy back Merrill's interest in some power barges that were going to be used to provide emergency power to the country of Nigeria, actually at the request of the U.S. State Department, because Nigeria was in turmoil, civil war, and the country needed electrical power. So Merrill agreed to invest $7 million, which is a relatively small amount. That's less than, right. I think it was less than 1% of Jim's group's investments at the time. And for Enron, that was next to nothing. They were a $400 million corporation. So they did the barge deal. The government claimed there was a guarantee. The Merrill guys said no. The most they promised was that they would use their best efforts to find an industry buyer for the barges within 6 months, because Merrill didn't want to be in the barge business forever. They owned other power stations. They owned some significant power stations in the country, but they really didn't want to be long-term invested in anything going on in Nigeria. So it boiled down to whether the deal was a sham, as the government called it, in that it was a loan instead of a properly reported gain, or whether there was a guarantee or it was just a loan.
Right.
Long story short, the jury found, based on the prosecutor's case, that was hearsay only. They didn't have anybody that was actually a participant to the conversations testify. Instead, they proved their case purely by co-conspirators' hearsay, which is why they alleged a conspiracy to begin with, I'm sure. So nobody who had participated in any of the conversations testified for the government. And they convinced the jury that Andy Fastow and Jeff McMahon, Enron's treasurer, had given Merrill Lynch a guarantee that Enron would buy back the barges and Merrill wouldn't lose any money on them. My client had actually told Merrill and everybody he could find at Merrill not to do the deal. He didn't like it. He didn't want anything to do with barges in Nigeria. He had plenty of power plant investments from his group where he was in this country, and didn't want anything to do with Nigeria. He saw all kinds of risk associated with the transaction, and he knew there was no guarantee against those risks, which is why he was so adamant that it was too much risk for Merrill to take on.
Right.
But the government convinced the jury that the deal was a sham, that the guarantee that Enron had made the guarantee, and convicted all the defendants, all the Merrill defendants, of depriving Enron of the honest services of Andrew Fastow under the very vague honest services statute and the conspiracy statute. So these 4 Merrill executives went to prison, being denied even bail pending appeal, while we pursued the appeal of their convictions on the honest services. And in addition, my client, Jim Brown, was also convicted of perjury and obstruction of justice for expressing his personal understanding of a telephone call that he was not even on.
Wow.
Yeah. And that was after the prosecutor, Andrew Weissman, who later wound up heading up the FBI as general counsel and deputy director. That was after Andrew Weissman had told him in the grand jury, share your personal understanding with us, whether it's accurate or not.
Yeah, that's hard to call that perjury then.
Yeah, it really is. And on top of that, it turns out that all the evidence they hid substantiates is identical to what Jim told the grand jury. So it was literally true. He had been told to give it whether it was accurate or not, and he didn't even know who had told him that. It wasn't based on his personal knowledge at all. So how anybody can affirm a conspiracy and obstruction of justice conviction based on that is beyond my comprehension, but the court did.
For us that don't know the workings of some of these kinds of companies and stocks and such things, tell us why this is such a serious offense anyway. I mean, again, coming from Canada, we don't prosecute any. There's no white-collar prosecution like this in terms of how zealous they are to give these guys serious sentences. And so tell us what kind of sentences they were looking at giving these defendants, and why so serious? What is it about the crimes themselves, this honest services clause? What's so serious about the crimes themselves that they warrant these kinds of sentences?
That is very hard to say. All I can tell you is that this little elite group of prosecutors decided they wanted to send a message to Wall Street. Most of them on this team had some relationship with the Southern District of New York, and at least Leslie Caldwell and Andrew Weissman had been used to prosecuting gangsters. They called these bankers wise guys on Wall Street. So they basically used organized crime tactics against these businessmen and felt like they needed to send them to prison for 25 to 30 years, even though these guys didn't take a dime from anyone. Enron made $53 million on this deal. Merrill Lynch made, I think it was $750,000 on the deal. And these guys were literally just doing their jobs that day. The judge, even when he sentenced them to 3 to 4 years each, said, I recognize you all were just doing your jobs, but you've been found guilty of this offense. Now, of course, the judge refused to recognize that the offense itself had been made up. They had pieced together parts of different statutes, and there's never been a valid honest services conviction in the absence of bribery or kickbacks, and there were no bribes or kickbacks in this case. So there was no offense, but it took us 9 to 12 months to get the Court of Appeals to recognize that after the district judge refused to. So the whole thing was a tempest in a teapot made up by the prosecutors who just had a thing for these particular defendants and wanted to bring Wall Street down a notch after they'd also wrongfully destroyed Arthur Andersen, LLP, the accounting firm, for nothing. Lost 85,000 jobs over nothing, only to be reversed by the Supreme Court 9-0.
Right. Now, you talk about the personal life of Jim Brown and his wife Nancy and the ramifications of all of this. Were you a friend or some colleague or an associate before this? Tell us about your relationship with Jim Brown.
I did not know them at all before this case. But when you go through something like this with someone, you get to know them pretty well. And we worked together in his defense for almost 7.5 years.
Wow.
The entire teenage span of his children.
Incredible.
So, yes, I got to know them very well. And when Jim was in prison, I would talk to Nancy on a regular basis. It was extremely difficult to talk to Jim while he was in prison. That was a whole new experience for me. I'd never had that much trouble talking to a client in prison before. But the prosecutors did everything they could to make everything as hard for these people as possible. In fact, our youngest criminal defendant was put in a maximum security transfer facility. I think it was hundreds of miles from his young family, with the worst of the worst.
Wow. How can this occur without, I mean, temporarily anything can happen, I'm sure, but didn't someone petition for, again, you know, you have some sort of right to be closer to your family unless there is some other pertinent reason not to be. And communications with lawyers, I was very, very shocked. I'm glad you brought it up because that's one of the questions I want to have for you. How common is it for somebody to be denied access to a lawyer, and especially given who you were and who you are?
I have no idea, but it was a fight to get to talk to him every single time. And apparently he paid a penalty inside the prison for my aggressiveness in pursuing my right to talk to my client.
Yeah, I found that interesting. Sorry, go ahead.
I don't even know all the details of that.
Yeah, you paint a picture in the book about him being roughed up by guards, and other than that, what was the treatment overall by inmates? Again, we already just talked about the guards, some of them not giving him a hard time. What was his overall treatment there, and what was the result? You described that in the book as well, his imprisonment.
Jim came through it better in many ways than some of his colleagues. Jim is a very affable guy, and he went into prison with what I call and describe in the book an attitude of gratitude because of a serious personal experience that I don't want to give away. I want to encourage people to read the book to understand all of it. But he really went into prison with an attitude that he was going to make the best of it and try to help other people. And that made him a lot of friends. He had a few close calls, but by and large, he came through it very well and is out now and putting his life back together.
Tell us about the tactics that you used, the strategy that you employed to be able to reverse this decision and get him released from jail. Tell us about that.
Well, as soon as I read the indictment, I realized it didn't state an offense. I mean, I had read literally hundreds of indictments, used to help my colleagues draft indictments when I was in the appellate section. It should not be difficult at all to read an indictment and tell what the crime was.
No.
And I read this indictment, and I reread it, and I reread it, and I reread it, and I couldn't figure out for the life of me, either factually or legally, what exactly the crime was, because none of the defendants had taken any money from anybody. They hadn't taken any property from anybody. To say that they deprived Enron of the honest services of Andrew Fastow, who was the primary crook at Enron, all on his own, long before these guys knew anything about it, would be laughable if it weren't for the fact that they spent a year in prison. I mean, none of it made any sense. So my strategy was to take the indictment apart and explain to the court how it simply did not allege a criminal offense, and to look at other cases across the country. There was not a single case from any court affirming a criminal conviction on facts like this. And that alone meant they should not have gone to prison pending their appeal. But they did.
At what point did you find out, and how did you find out of the Brady Rule infractions?
Oh, that took forever. That was actually an accident. The third set of prosecutors accidentally produced to me, well, they deliberately produced to me a CD, but they didn't realize, apparently, that it had on it the yellow highlighted information by the original prosecutors from the trial back in 2004. So when we saw the yellow highlighting, I realized exactly what it was, because they had given us a summary of Brady information instead of the actual documents. Of course, the defense lawyers at the time had asked for the actual documents, and without the actual documents, you really have nothing. But all Judge Werlein would order was the summary, and he didn't even review that to make sure it was accurate. Obviously, it wasn't, and we couldn't get anything else. He either ignored our motions or denied them. So 6 years later, I review this CD that's produced to me, I think, on like March 31st of 2012, and go, holy cow, I know what this is, and proceeded to do a motion for new trial. We were still in litigation as to whether Jim would have a second trial at that point. They wanted to re-prosecute him, even though the Fifth Circuit had declared that the conduct charged in the original indictment was not criminal under the honest services statute, and it certainly didn't allege a traditional mail or wire fraud because no money or property was taken. But the government had come up with another newfangled theory to try to get around that, just because they were determined to drag him through everything they could drag him through. And a large part of that was because we had alleged the prosecutorial misconduct.
Right. So they weren't successful.
No, they were not successful. They wound up walking away from the conspiracy and wire fraud convictions literally on the eve of the second scheduled trial, after running us up right to the last.
Wow.
And we also we had to seek a new trial on the perjury and obstruction convictions because the Fifth Circuit had affirmed those, but we never got a new trial granted on those, or even a hearing on it. Couldn't even get a hearing on it, despite the yellow highlighting, which meant that the prosecutors knew it was both favorable to the defense and material to the defense. That's why they yellow highlighted it. They had yellow highlighted it as Brady before the first trial 6 years earlier, but Judge Werlein didn't care about that either.
You talk about the wire fraud, a couple charges, including the wire fraud, that were not pursued. Was that because he had already served what he would have served anyway, more than likely?
They claimed it was because of prosecutorial resources, but yes, actually the government had agreed to his release at the time the Fifth Circuit came out with its first decision reversing the conspiracy and wire fraud counts, because he had served the maximum term of imprisonment that could have been imposed validly on the perjury and obstruction counts at the time, if those had been the only counts for which he'd been convicted. So they had already gotten their pound of flesh, really, anyway. But they were still determined to drag him through as much as they could, and were going to pursue counts 1 through 3 until we got right up to the eve of trial. And I had hammered them with the motion for new trial and the exculpatory evidence they'd hidden at that point. So they were kind of caught with their pants down, so to speak.
Now, what about sanctions against these people that have engaged in prosecutorial misconduct and judges that were involved as well?
Absolutely nothing can be done with respect to the judges, and virtually nothing can or has ever been done about the prosecutors. Even after Schulke's report, which was very damning of the prosecutorial misconduct in the Stevens case, nothing really happened to those prosecutors, 2 of whom were found to have hidden evidence, or at least not met their ethical obligations. In the Department of Justice's own study, one was recommended for a 30-day suspension. The other was recommended for a 14-day suspension of pay, and that didn't happen for either of them. And with respect to the prosecutors in the Merrill Lynch Enron case, not only nothing happened to them, but they were promoted to positions like Chief White House Counsel and General Counsel Deputy Director of the FBI and Acting Attorney General for the Criminal Division of the Department of Justice. And Leslie Caldwell, who destroyed Arthur Anderson, is now the nominee for the Criminal Division of the Department of Justice.
This is incredible. So again, I just don't understand what the motivation is for these people to risk their own careers.
They didn't feel like they had any risk. Nothing happens. Prosecutors have what's called sovereign immunity. They're protected by the fact they work for the government, and it's next to impossible you can't prosecute one of them for anything done in the course of their duties, and there's no civil liability for them absent extremely extraordinary circumstances that are very difficult to prove, and I don't know of any prosecutor that's actually been held liable civilly. And the bar associations didn't want to do anything about these people, presumably because of where they are now. I don't know. It's just the system needs some work.
Now, other than you being certainly disappointed from the idealism that you went into this profession with, and the optimism, even as a prosecutor, you must be disappointed. But it seems like, and I'm probably not have to be a detective to figure this out, License to Lie is really more than just a book. It is your effort to enact some kind of change and to inform people, even within the judicial system, of specifically what's wrong and why and when.
That's exactly right. That's exactly right, because there are things judges can do right now to make the system better. We don't have to wait for Congress. Judges can enact what's called a Brady compliance order in every case that appears on their docket and make the government produce the real documents instantly and impose penalties instantly if they don't. And pending before Congress as part of a bipartisan effort 2 years ago now is the Fairness and Disclosure of Evidence Act. The only group that I know of that opposes that is the Department of Justice itself, which just makes me sick. And there's also been a proposal recently, again bipartisan, to provide an inspector general and give him an authority to investigate allegations of misconduct against Department of Justice lawyers, because another group, the Project on Government Integrity, I think it's POGO.org, came out within the last month with a report of over 600 instances of prosecutorial misconduct in the last several years, over 400 of them being intentional, and the Department of Justice is refusing to release the names of the prosecutors who engaged in that intentional misconduct or to notify the defendants whose cases were infected by that intentional misconduct. So they're circling the wagons and hiding all of it and protecting the prosecutors.
You know, for those that live outside of the U.S., again, I'm from little old Canada here, where we barely can convict anybody of anything, and we believe we can rehabilitate anyone of anything. So it's incredible contrast, we'll say, to say the least. It seems like, and I mean, yours is not the only story, but your book is the most incredible demonstration and illustration of how the tables seems to have turned in terms of, again, a narcissistic prosecution with political aspirations and wants to win at all costs, and does things like have exculpatory evidence that could exonerate who they're prosecuting, but no, they go ahead. And like you say, a judge who is supposed to be the arbitrator, supposed to be the person that stands, that has the ability to allow or disallow, again, things that would be a miscarriage of justice. It almost seems like there's used to be the sleazy defense lawyer, we used to think.
Right.
And the virtuous prosecutor. But now it's the virtuous defense lawyer with the sleazy prosecutor. It seems the tables have turned.
I think that's a fair assessment. They have in a lot of cases. It used to be that judges could trust the assistant U.S. attorney, and I still think they can in a lot of districts where they have that one-on-one relationship with the assistant U.S. attorney who appears in the court day in and day out, and they know what kind of credibility that person has and, what their level of integrity is. But then again, you have these high-profile prosecutions by Main Justice and even some slimeball assistant U.S. attorneys in various districts that need to be fired. I mean, why the Department of Justice lets anyone continue to work there who has intentionally violated Brady is beyond my comprehension.
Well, that's a question I would have, too. I don't understand, for something that we hold up in such high esteem, I don't understand there's no control of that. It's like having a bunch of cops with a bunch of, that have multiple assault records. It doesn't make that much sense in terms of the community, in the community. So
right, it makes no sense to have Department of Justice lawyers who intentionally violate the law. I mean, if I were Attorney General, every one of them would be fired.
Now, you are naming some names in your criticism in this book, and you're not holding too much back that I can see anyway, that
right.
I can read. What has been when did this book come out, when is the book scheduled to come out, and what has been the overall reaction? And can you give us any personal sort of examples that either surprised you or just kind of interesting reactions?
The book is actually coming out May 1st. It's available for pre-order now at www.licensed2lie.com or Amazon, Barnes & Noble, IndieBound, Books A Million. Everybody's got it up for pre-order. And books should start shipping the very end of April, May 1st at the latest, I would think, and it should be in the stores by May 1st. So the only reaction so far has been from the few people who have seen some galleys, and that has all been astonishingly positive. People have said, wow, I'm so glad somebody's got the guts to tell the truth, and have applauded my willingness to step out in front on this issue and let people know what happened in these cases in a way that hopefully every citizen who's interested in politics, justice, law, economics, any aspect of our business world and legal world can understand.
Yes, and then you touch on so many, important historical points in America, and really bring the story in you paint a very, very vivid portrayal of, like, say, Jim Brown and his family going through this, and Nicholas Marsh committing suicide. So this is not a book full of statistics. This is someone, as I described while I was waiting for you to reconnect to the program, is that somebody that really has a unique perspective from being a prosecutor and then seeing the good and the bad. And so your perspective is much more valuable, and with this book, very, very interesting, all the cases that you bring together and draw parallels to make this illustrate some very, very important points about the judicial system.
Thank you. I wanted people to see the human story. I want judges to remember that every case they touch, whether it be civil or criminal, involves somebody's life and has a big impact on the lives of more than just the lawyers standing in the courtroom arguing the case. I always tell my clients, this isn't my case, it's your case, it's your life. And that's what cases are about. They're about people's lives and livelihood, and particularly criminal cases. And what people go through when they're the targets of a government investigation is unfathomable for anybody who hasn't been through it.
Well, it's very incredibly, perversely ironic to think that we have set up this elaborate system,
we've come so far away from the public lynching and hanging and people taking, justice into their own hands, literally, that
right.
we have the truly innocent being persecuted again, and then when these cases are reversed, there's no atonement, there's no remorse, and so it's incredibly perverse.
There's not even any recognition of the fact they've been reversed.
Yeah.
Most people don't even know that Arthur Anderson, after being destroyed by a criminal indictment as the first corporate criminal in the history of our country, the case was reversed 9-0 by the Supreme Court because the prosecutors took criminal intent. Again, they had pieced together parts of different statutes to make a crime where there wasn't one and taken criminal intent out of the jury instructions to get the conviction.
Well, it's partly the media, too, because that doesn't make for good print,
right.
reversals, and, that's not very... They love to see someone destroyed. So.
Right.
Never mind getting the facts straight, so partly responsible here. But as you described, too, I find it this incredible relationship between the media that, again, is another respected bastion of, again, representing the truth when sometimes no one else does.
Right.
And it's irresponsible.
Yeah.
Again, especially when someone's case is reversed, it should be, they should really have to go out of their way to explain, since they jumped on the bandwagon of guilt well before someone's actually pronounced guilty. I think it's, it's an ideal world, I guess.
Right. Yes, one would hope that our press would focus more on protecting individual freedoms as it was originally intended to do than being a mouthpiece for the government to achieve its ends.
Yes, and you do touch on in the book, too, just then, so before I let you go, I touch on what you think it demonstrates to the Snowden case in hiding out in the Soviet Union and talking about real crime. So tell us what, just not to give it all away, but really what you touch on in your commentary about this.
I'm not sure I'm following your question.
Well, you talk about Eric Snowden and revealing crimes, and again, talking about the U.S. government if they're looking for someone to prosecute. It seems ironic.
If they want to prosecute you, it doesn't matter whether you've committed a crime or not. They'll make it up, and they'll make up the facts, and you're going to be in prison. I mean, once somebody's indicted anymore, there's no presumption of innocence. The presumption of innocence has gone to hell in a handbasket. And, grand juries that used to kind of stand in the way between a prosecutor going berserk and indicting somebody that shouldn't be indicted, just rubber stamp whatever the prosecutor wants for the most part. I never knew a prosecutor who couldn't get a grand jury to go whichever way he wanted. So It all boils down to prosecutorial discretion. And if the government wants you in prison, you're going to be there.
Well, that always seems to be the case anyway. But having someone appeal their case many years later, make it all the way up to the federal court, that's what we see. Sometimes that this is justice is done. But how many years? Right,
10, 15 years down the road.
Yeah, it's an incredible sentence. Yeah.
Yeah. Look at all the recent exonerees because DNA showed they were innocent. Some have served as long as 25 years in prison for something they didn't do.
Yeah, that's incredible.
We've got to do a better job of making sure we convict people who are only guilty, not the innocent.
What I think is interesting, too, living in Canada, is that we really are hesitant to file charges, prosecutors, unless those charges are, like, they won't take circumstantial evidence to a jury. They just won't. So I know there's a difference in certain ways of handling the cases completely. I won't get into that right now. But it seems fascinating, the complete opposite, where we almost cannot convict someone without a confession, DNA, and a body, we'll say in a murder case, whereas in the U.S. they take circumstantial cases to a trial. They take not that much evidence to a grand jury. Prosecution, as you say, goes with very thinnest of motive and, again, without intent. How are you really filing charges if you can't say this is why this person did it, or this is what they actually did?
Right.
So it seems, I guess, to other people that live in other countries that might be listening to this program, that the U.S. has, I hate to say it, but when you get reports of almost every university, every state having a university that has an innocence project from overzealous prosecution, I don't know how you can really pound your chest and say, look at our incredible judicial system with more people in prison than anybody else on earth, and a book like yours and so many cases of, again, innocent people being imprisoned. It's incredibly ironic.
Yes, I think our focus has shifted way too far toward convicting anyone that's brought before the court and even indicting people that don't need to be indicted, as opposed to making sure we're prosecuting actual criminals. And when I was a prosecutor, we really didn't have that much trouble telling the difference. I don't know why they're having trouble these days.
That's incredible. Yes. Well, you've done an admirable job with this License to Lie, and incredible story exposing corruption in the Department of Justice, and from someone that's, an insider's insider. So thank you very much, Sydney Powell, for coming on and talking about License to Lie.
Appreciate your kind comments and having me on the show.
Well, thank you very much. It's been very enjoyable. For those, again, who might want to contact you, could you give us your contact information? And if you do the Facebook thing, let us know as well.
Yes, License to Lie has its own Facebook page. I'm on Facebook as Sydney Powell, SIDNEY POWELL. And the website is www.licensed2lie.com. And books can be ordered through that.
Well, thank you very much. I wish you the best in any kind of change that might come as a result of this fine book, and I guess really the cause that you are following with this. And thank you very much for this interview, and have a great night.
Thank you, Dan. I appreciate it very much.
Thank you, Sydney.
Bye-bye.